In 1919, just a rush of First Amendment cases testing free speech versus national security. Spoiler alert, national security wins in every instance. So what you say in 1919 might be different from the standard that's applied in 1928. That seems a little strange, but hiding behind designations of national security of classified nature puts governance in a shadow, and it removes it from the public.
Hello YouTube, this is Ben Barr coming to you today to talk about the TikTok free speech case before the United States Supreme Court. I'm a First Amendment attorney who has spent most of his professional life working on complicated and controversial free speech cases. And rather than launch my channel with witty tales about my background and a very long introduction, I thought the best way is that we just jump into a very pressing free speech issue today. And the TikTok case, of course, is about the issue that ByteDance, a Chinese-owned company, operates a very popular social media platform, TikTok, where somewhere between 150 and 170 million US users, so roughly half of the United States population, are actively using this. Now, the US government alleges two main theories about why ByteDance must divest its ownership and sell TikTok to another American-based company. The first is that the Chinese Communist government is actually using TikTok as a means to cause agitation within America, to disrupt national unity, and to do this over a long period of time. The second argument that it advances is that TikTok is less a social media platform and more of a long-term spying device, that it's doing surveillance on prominent and not so prominent Americans and collecting a very sophisticated and large database to be able to track Americans, and that this in some way impairs national security. Now, we have a long string of cases in First Amendment jurisprudence that examines this tension between the right to be able to engage in vigorous free speech and dissent versus national security concerns of the government. So I thought the best way for us to do this today is to start in the founding era and talk a little bit there, and then we jump into America's really first, in my estimation, its first big experiment with testing the waters of the First Amendment and national security early in the days of our republic. And we're in New York City today, so what better a place than we're going to head over to Tompkins Square Park, a location of famous protests in America, especially for communist, labor, and socialist-oriented speakers, and talk a little bit about World War I era cases that again test this dynamic between the right of vigorous protest and free speech versus the security concerns of a country. From there, we're going to walk on over to the location of the old New York Times building near Times Square. We're going to talk about the famous Pentagon Papers case. And then we're going to take all of these rules, all of this history, and try to distill what's going on in the minds of the justices in the TikTok case today. As we're filming this, we're about a few days out from hearing oral argument on it. We might update this if we see an early opinion in the case. But for now, let's go back to the foundation of America. Let's look at the late 1780s when we're putting forward the Federalist Papers. By we, that's Madison and Hamilton primarily. There's no discussion in early documentation about national security per se in free speech, but there is a great emphasis, at least in two Federalist Papers, number 10 and number 49, in which the writers are discussing the important role that factions take in a free society, that they are quite necessary to preserve civil society, as well as allowing for the free flow of public opinion to be able to develop in our republic. But it's 10 years later where this gets really interesting. So we're 10 years forward, we're at the late 1700s, 1798 or so, and we see the Alien Sedition Act. It's actually 4 laws that were passed by Congress. Now, what's going on at the time? At the time, France is engaged in a conflict with Britain. In France, because of its support for the United States during our revolution, expects that America is going to immediately jump in and support their cause against Britain. But that's not the case. America is very much in a position of neutrality, and this causes great tension with France. So much so that we have an undeclared sort of secret naval war that's going on with France. Shipments to Britain are being seized by the French Navy. We have the XYZ scandal that's going on at the time, which is where we have French diplomats who are asking for bribes to be able to be on the good side of the French government. And so Congress passes a law that says it's illegal to utter false or scandalous items about those in power. Well, as with any sort of scenario, of course, those who are in power at the time, the Federalist Party with John Adams as president, can use this great power to be able to go after dissenters. That'd be the Democrat-Republican Party, that's Madison and company. And so what we see is that we have cases where it's like the Thomas Cooper case, where you have a journalist lawyer who's writing about popular waste and President John Adams and his administration and being very critical of it. But he faces 6 months in prison because of this, and at the time a $400 fine, which was rather hefty. Even Benjamin Franklin's grandson was subject to the purview of the law. So we see a lot of high-level, prominent individuals falling prey to the reach of the law. It becomes very unpopular with the public because instead of it being targeted against supposed French intrusion into our press or French efforts to mold public opinion, which was the purported focus of the law, we see that it's being applied against those who dissent and those who are unpopular with those in power. And so much so, we get Jefferson and Madison, who issue the Kentucky and Virginia resolutions, who say, well, Congress may have passed this law, but it is of no effect whatsoever today. We never see any sort of judicial resolution of the Alien Sedition Act. I think that's unfortunate in our history. What we see is prominent individuals from the founding era speaking up against it, and we see its quick repeal in the early 1800s due to it being highly unpopular. But it takes nearly a century, more than a century, to moving forward to get to the next great collision between free speech interests, the right of dissent, the right to share provocative ideas, versus national security concerns. And all that takes place during World War I. We have a string of cases in 1919 that forces the Supreme Court to address these issues and formulate clear thinking, maybe, on the issue, or at least a standard that we can start to apply. So we're going to head over to Tompkins Square Park, a site of a hotbed for communism, for socialism, for labor speakers who wanted to oppose war efforts, who wanted better conditions for blue-collar workers, factory workers in America. And let's examine exactly how the Supreme Court treated that during the early 19-teens and 1920s, and what tests we might learn out of that. And then we're going to develop that even further so we can understand what's going on in TikTok today. Let's head over.
So we're here at Tompkins Square Park in New York City. It's a location of great civil unrest in American history. 1874 has the Tompkins Square riot that occurs, which is a hotbed of socialism and communism, and their leaders come into the park in a time of a recession in America, in a time when unemployment's very high, in a time when people are trying to fight for things that we take for granted today, like an 8-hour workday, and for better security in their jobs. There's also these weird fears that some of the rioters have smuggled in weapons from that same place that concerned the founding fathers during the early days of our republic from France, that there was Parisian weaponry coming into New York. And is so often the case with rioters, we find that in a protest movement, there's different factions. So in the story of the riot that occurred at Tompkins Square Park, we had a peaceful segment who had a clear set of demands that they wanted to present and do a march to City Hall. And we had a more radical element who was willing to engage in violence and use violence to be able to reach their ends. So what's interesting, what happens in 1874 is you see that there's at least two factions, as we see in a lot of protest movements. One faction is dedicated to peaceful protest, means they have a list of demands that they want to present to City Council, and the other faction is committed to using violence and being more radical. Unfortunately, what this means for all the protesters is that over 1,000 police officers descend on this rather small park, not only in the park, but they use a police patrol on horseback around the park to be able to go after people with batons, be able to silence some of the lead speakers that were here during that event. So clearly, in this sort of a setting, the voices of labor, the voices of socialism, voices of communism lost out. And probably because of the provocative nature of their message and because part of their protest movement was dedicated to violence. But New York City has a host of interesting and provocative speakers that have occupied their place. And it's one of the first times in American history that we start to see this tension between free speech and national security is during 1919. So we're into World War I. We have heavy recruitment and draft efforts going on in the American military. And the first case that we think about is with a man called Charles Schenck. He comes out of Philadelphia. Charles Schenck is the General Secretary of the Socialist Party in America. He's also a union leader, and he's giving speeches that are rather hypothetical in nature. He's asking for people to assert their rights and to be able to engage their government and their democracy. And this is seen as an effort under the newly created Espionage Act to undermine military readiness of America in World War I. So the case comes up to the Supreme Court, and there's no clear test. Every area of First Amendment jurisprudence develops a doctrinal test to be able to settle disputes. At that point, there's no clear test that has been set to do so. And it's Justice Oliver Wendell Holmes, who has a prominent role on the court and is an intellectual, who develops a clear and present danger test. And so he asks under this formulation, if the proposed conduct and speech that's being engaged in by an individual or a group poses a clear and present danger to society, to government, and you can show that through evidence, then we're going to have not protected speech, but an area that the government's able to regulate or even ban or punish. They also caution that this is a special case. This is during a time of uncertainty. It's during a time of wartime readiness, and that the full extent of First Amendment rights might not be at their zenith during that time. The second case that we want to look at is Abrams versus U.S., and that involves a series of challenges right here in New York City, where we have Russian immigrants who are upset that the United States government is intervening in the Bolshevik Revolution in Russia. So they create a series of pamphlets that say what we think of as otherwise pretty innocuous speech. They tell individuals that they should rise up. Let me grab this ball here. There you are. Tell citizens to rise up. Their biggest call to action was that laborers in ammunition factories should strike. And the U.S. government took great offense at that because in the middle of World War I, if they didn't have laborers in their ammunition factories, well, then there were going to be some issues. And so this came to the Supreme Court, and we see that Justice Oliver Wendell Holmes, who developed the clear and present danger test in Schenck, suddenly retreats from that position. Both he and Justice Brandeis, who later becomes a rather famous justice for his First Amendment and constitutional jurisprudence, look at the nature of the speech and they say, well, of course you have a right to dissent in free society. You have a right to be able to engage in criticism of the government, criticism of the seated president during wartime. And clear and present danger doesn't mean this sort of hypothetical advocacy. It means something different, something more direct. So when I use the term call to action, that's something that was on the minds of these dissenting justices, and something that poses an immediate and clear threat to the U.S.'s interest. And they didn't think that poor Russian immigrants who were stating their mind about U.S. military intervention reached that level. Now, we'll move on in case law and we'll see that Justice Brandeis and Justice Holmes have a chance to revise that in future cases. So the third case that's interesting here, again, 1919, just a rush of First Amendment cases testing free speech versus national security. Spoiler alert, national security wins in every instance. This one is Eugene Debs. He's a famous candidate for the Socialist Party, running for president. He's also a labor leader. And he gives a speech to the Socialist Assembly praising the Socialist Party and giving great praise and encouragement to those who resisted recruitment efforts for World War I. This again catches the attention of a rather nervous Woodrow Wilson administration, and they move under the Espionage Act to criminalize and punish the speech of Eugene Debs. Now, the court finds that this sort of speech meets the clear and present danger test. That is, without military readiness, without military recruits, America wouldn't be able to successfully engage in World War I. And they, at least in this case, go to a great effort to discuss that this is the standard that we're going to use during wartime. That during wartime, the standards might be different than the advocacy that they would find permissible during peacetime. So what you say in 1919 might be different from the standard that's applied in 1928. That seems a little strange, but the Supreme Court reasoning would be that the interest that government has in preserving the national security, the national unity, is much stronger during that sort of time of national unrest and during a time of threats to the very existence of the nation. Now, we take the culmination of these cases, that is to say Schenck, Abrams, and Debs, and what we need to do then is to sort of fast forward into the 1960s, because we're going to look at the Brandenburg case, which is a chance for the Supreme Court. In America, we're facing a time of somewhat of a cultural revolution, a loosening of cultural norms, and really greater respect for free expression. And Brandenburg is an opportunity for the Supreme Court to revisit the clear and present danger test and to be able to give it new meaning. 1969. We get to the case of Brandenburg, which is the next opportunity for the Supreme Court to revisit exactly what clear and present danger means. Because you'll recall that between the Schenck case and the Abrams case, that it's something of a Frankenstein monster that Justice Holmes had created. Because in Schenck, he develops the clear and present danger test. But in Abrams, he's shocked to see the majority of the Supreme Court say that hypothetical, peaceful dissent can somehow be suppressed. So we get to Brandenburg, and this involves something that's common in the First Amendment. Sort of ugly, ignorant speech, but speech that's still protected. The Ku Klux Klan has a rally in Ohio. And during that rally, there's a line where the speaker says that if the US government, if the Ohio government keeps ignoring the Klan, then they might have to take some revenge against them. So it's a very conditional and hypothetical statement. And the Supreme Court gets to the point where it can say, does the clear and present danger test work? Because what was alleged in the case is that even this sort of hypothetical risk, similar to what we saw, you recall, back in the case in Abrams, even that hypothetical risk, we might have to take some revenge against the government actors. Does that meet clear and present danger test? And the problem with the test that you see from Holmes is that it became too subjective. It became too moldable by justices to meet their particular biases or their particular issues that they were interested in. And so what the Supreme Court does is say, look, speech becomes unprotected when it is going to incite imminent lawless action, right? So we can see that there's a danger, but just a hypothetical danger, something might happen down the road, isn't enough to make it unprotected. And it has to occur in the immediate future. So if I call out a threat to do something violent against someone across the street now, that's unprotected. If I talk generally about doing it years from now, it's bad speech, but it's protected under this test. So what we see is we're heading into the late 60s, like I mentioned before, sort of a cultural shift, more protection for free speech, sort of a more Madisonian view of how widely this goes, and only very stringent and narrow areas where government's going to be able to operate and shut it down. So we allow in Brandenburg a general call for hypothetical incitement by the KKK, because we realize that there's going to be all sorts of people, like Russian immigrants and Abrams or other protesters in the future, who might come close to that line, and we need to give them some space to be able to do that. All right, we're going to wrap up here at Tompkins Square Park, and our next destination is to head to the former building of the New York Times to explore the Pentagon Papers case. So there we move into the Vietnam era and the Vietnam conflict or war and leaking of top secret information to the American public, and whether free speech interests weigh out there or whether national security will once again carry the day. And we have to take the culmination of Schenck and of Abrams and of Debs and of Brandenburg and combine it with some other Supreme Court First Amendment jurisprudence to be able to get to the answer. And then that will finally allow us to maybe scratch at what the Supreme Court's thinking about in TikTok. Let's go. Okay, we are here on West 43rd Street in New York. We've left the Village and we're just in the Theater District. We're going to be walking by the location of the old New York Times building. They sold it in 2007. I believe its current occupant is Yahoo, but it occupied this space for some time, and during the case we're going to talk about, Pentagon Papers, this was its location. Unfortunately today they're doing some work and refurbishing on it, so it doesn't make for a great view, but we'll keep talking. Pentagon Papers case, you can learn a lot easily, so I don't think we'll spend a great deal of time on the case, but we'll go over some of the key facts. Daniel Ellsberg was working for the Rand Corporation, and the United States was involved in the Vietnam conflict. There had been a Department of Defense study that had been commissioned that included some critical looks at chances of success in the Vietnam conflict, as well as likely number of casualties and other predictors of what would occur in this conflict. Mr. Ellsberg decided to leak that to the Washington Post and to the New York Times, and in deciding to move forward with that, the Nixon administration claimed that any release of the information in the confidential study would pose a grave threat to the national security. So we have a very quick resolution of the case. It moves through federal court at a breakneck speed, reaches the Supreme Court, and the Supreme Court does not allow an injunction as requested for by the Nixon administration. Now remember, we need to go back to the cases that we just discussed, and the most recent one was Brandenburg, where we talk about there being some sort of an imminent concrete effect. We have, of course, that clear and present danger test that we discussed earlier, but we need to see some sort of imminent impact that's going to have a concrete impairment. Now, what we get out of the Pentagon Papers case is not one single opinion, but if you look at it, we have 6 concurring opinions from justices. So imagine if you are a patient and you have cancer and you see 6 doctors and they each give you 6 different ways to treat your cancer. You'd be in a sort of confused state. The same held true in Pentagon Papers, because instead of commanding one majority opinion, we have 6 splintered opinions. And this creates some tension in what we see. And we'll discuss the tension between the justices and what that means for future cases in just a moment. Now, what makes this case a little more difficult is that it's not just about national security. The Pentagon Papers case involves a doctrine called the prior restraint doctrine. In First Amendment case law, we absolutely despise any attempt by government to prohibit speech from actually occurring. There's a number of instances where we'll allow speech and then allow for there to be a remedy after the fact, but we never ban speech in the first place. And so part of what made this so difficult of a case for the Nixon administration to be able to uphold is the fact that they wanted an outright ban before the speech could occur. So we get these 6 concurring opinions going different directions. All right, so we have some splintering of opinions in the case. And Justices Black and Douglas, who hold views on the First Amendment similar to my own, that's to say an absolutist position, indicate that the framers already did all the balancing that needs to be done. And even if the government shouts national security, there's a greater value here, and that is citizens getting to know about the workings of their government, about what's really going on. That promotes democratic accountability, and there's no real weighing or balancing that has to occur. But we see individuals like Justice White who show extreme deference that once government says the magic words national security, that we're going to have less protection for free speech, and we're going to treat these government pronouncements to have a high level of authority and seriousness. So this tension between deference to governmental declarations versus a loyalty or fealty to the original command of the First Amendment creates some schism between the justices. We wind up with an otherwise, if somewhat schizophrenic and splintered opinion, one that protects free speech. The justices seem to agree that if you were able to get to a situation where you were revealing during wartime the locations of troops, sailing dates, armament locations, that might rise to the level of that sort of imminent, concrete harm that would hurt national security. I don't know if you get Justice Black onto that opinion, but you get a majority of the Supreme Court that might limit speech. But with the Vietnam conflict, what we had was speech that seemed very important to an issue of the day. That is, the public was very interested in the Vietnam conflict, the Vietnam War. And this was revealing that maybe what they had been taught, maybe what had been shared with the public, wasn't really truthful, wasn't accurate. So it's high-value speech, and even in the face of nebulous claims about national security, free speech wins out. Unfortunately, not in a consistent way, not in a way that commanded a majority of the Supreme Court, but it's what we're left with. And importantly, it's what we're left with for looking at the TikTok case, which we're about to discuss in a moment. All right, so we've worked through a pretty big set of First Amendment cases to get back to TikTok. We went through Schenck, we went through Abrams, we went through Debs, and we talked about the clear and present danger test. We went to Brandenburg and we modified that a little bit. We've talked about Pentagon Papers and examined 6 different opinions from 6 different justices going in different ways but upholding free speech. Now we have the TikTok free speech case before the Supreme Court. There's some key differences between what the court is considering here versus what it's considered in prior national security cases. Involve the fact that the first would be that we're not at wartime. During World War I, we saw the first set of cases involving the right to pamphlet, criticize, and engage in dissent. And the court makes careful note at times to indicate that when we're in wartime, when we have a direct military conflict with another nation, that our natural rights might be reduced or that government might have more authority to act to suppress them. But when we're not at wartime, that we should expect the opposite to occur, that free speech should be the norm. And so we know from Brandenburg and the other cases that we have to see some really compelling harm that's going to occur to government and the national security. We know that from Brandenburg that it has to be imminent and it has to have some sort of a concrete shape. So where does that leave us with TikTok? Now, the arguments that were alleged by the government here are that TikTok is doing one of 2 things, or perhaps both. It's creating some sort of social disruption and disrupting national unity by creating agitation for users, creating unrest in America, or that it's doing a wide-scale surveillance program, and that is injurious to America. Now, there's a key evidentiary problem here, in that the evidence that the United States government is putting forth is deemed classified, top secret, or the like. So opposing counsel, those who are representing TikTok, those who are representing people who want to receive speech and use the platform, don't even have access to the evidence that they have to confront that would support the government interest at hand. That makes it a very difficult argument, perhaps raises some due process implications for the TikTok folks in terms of being able to advance their arguments. Because in every contest for this, you should have the right to be able to assess what your opponent is promoting as this governmental interest. So what is the national security? What are these plans? And then to be able to use the evidence that you have or the precedent that you have that might be able to defeat that. So they're operating somewhat in a black box. Although the government indicated in prior filings that you don't even have to rely on that evidence. So the government's pushing sort of if we say it's national security, then that will always trump the First Amendment perspective. And Justices White and Stewart from Pentagon Papers would certainly agree with that position. They're going to always treat the executive as having a great level of deference to what their determination is for national security. Whereas justices who have more of a bent on originalism, who take the text of the Constitution a bit more seriously, are going to be less deferential to those determinations. So now none of us really know what's happening in that black box either. Maybe it is the case that the government has produced solid, concrete evidence that there's a mass surveillance program that's going on by the Chinese Communist government. And it is working some great harm against America and against its citizens. Maybe there has been evidence produced that there are plans for social disruption, for agitation, for working against our national interests and some sort of national unity. So we also have interesting evidentiary questions here, which we normally think of as fairly boring in the law. But what's happened is that the Department of Justice, the government, has signaled that the evidence here is classified, secret, and the lawyers for ByteDance, for TikTok, are not even allowed to access that. So a normal part of litigation is being able to see the evidence that your opposing counsel relies on and being able to weigh that and be able to make counter arguments to show it works, it doesn't work, where are the weak points. None of that's available. None of it's available to opposing counsel, lawyers for promoting First Amendment interests here. None of it's been made available to the American public. That's troubling to me. I think a better position for the federal government would be to at least have some summary, at least have some tidbit of this made available to the American public so that we can trust it. If there are plans from a foreign adversary that's dangerous and that's antagonistic to the U.S., let us know about that. Put that out. And I think you'd have far less of a contentious issue before the United States and its populace, and I think that's a harm. Something of this needs to be made available. Now, there are a lot of other segments of this case that we can go down. In the prior cases involving national security and free speech, the focus was always on the content of the speech. So you'll recall back in Schenck and Abrams, it was about things such as resisting recruitment efforts or suggesting strikes that might occur at ammunition plants and the like. So we're doing a deep dive into content that could directly harm, speech content that could directly harm the United States government and its war readiness. Here, of course, we're not at war, and we're not looking at the direct content of speech per se. And one of the arguments that's being put on by the US government is that this isn't speech. We are disabling algorithms, we're disabling a technology, and speech can still occur in whatever way you might like for it to occur. So the unique aspect of this is we're not focusing on the content of speech like we were in the World War I cases, where we were talking about pamphleteering, where we were talking about strikes occurring at ammunition factories. What we are doing is talking about a platform. And the question is government regulating, banning, suppressing a platform, or is it suppressing all the speech that's unique and organic to that which happens in TikTok? And of course, TikTok's argument is that it's no different than the digital town square. That's where 150 to 170 million Americans want to get together. They figured out a way to do this and a way to be able to share their perspectives back and forth. And that government has no authority to be able to do so. Now, since the prior cases all occurred in wartime, all involved direct content of speech, it's a very high burden, especially post-Pentagon Papers, for the government to be able to sustain an argument that the actions of a Chinese company are going to create some imminent and concrete harm to the national security interest of America. We're not technically at war with China. It is slightly antagonistic at times to us and us to them. But it's difficult to rise to that level unless suddenly the Supreme Court is going to take a very deferential point of view and borrow from a few justices from Pentagon Papers in terms of government shouting national security. Now, it raises other interesting questions if we build that as a precedent. What about other Chinese companies? Are we going to allow Temu, for example, the very popular shopping app that's on phones today? Are we going to shut that down because of manipulation and Chinese Communist government ownership? I've got a DJI drone that I fly around and have fun with, and we've proposed banning DJI drones in the sky too. Are we going to shut down everything on that front? And what about all the unique ways that those items, in particular DJI drones, in particular TikTok, allow us as Americans to talk to one another? It's a very complicated issue, and I have a great deal of empathy for the justices having to decide this. I do hope for this. I hope that there is no grand deferential gestures towards simply the government shouting national security. Otherwise, that opens the avenues for abuse in the future, because anytime government wants to suppress dissent or the rights of speakers, as we did in the early era of the Republic with the Alien Sedition Act, we'll see that occurring. If there's real evidence that's out there from the United States government that China is engaged in some serious and detrimental efforts to injure America, put it on the table. Make it available to every U.S. citizen and allow the Supreme Court to rule accordingly. But don't do so in the darkness. If the First Amendment stands for anything, it's for that level of transparency, and that will better bring the country together. That will better bring national unity, and that will protect free speech and a free press. I think we're going to wrap up today. It's getting cold in New York.
So as we get towards the end of this video, of course, we've lost our last video segment. My wife and I are new at this, so please bear with us as we get better with each and every video we release. So we use some of our stock footage and some of our B-roll film here to just wrap up our discussion. I think we're left with some rather unsatisfying answers about where this case is going to go. We have different strands of First Amendment case law and jurisprudence that we can pull from that justices can use to push the case in different directions. Of course, we went through some of the World War I cases in the early discussion on the video. And we know that the clear and present danger test evolved later into something with a little bit more rigor in Brandenburg. But we also know that when we go to cases like Pentagon Papers, that we see tension and we see schism within the Supreme Court about whether a more deferential stance will occur. Some justices take the executive branch at their word, and as soon as national security is said, they're very deferential to that declaration and less supportive of First Amendment rights. Whereas other justices take the very text of the First Amendment a bit more seriously and hold government and the executive branch to some level of rigor and scrutiny for them to put on evidence that would justify why any suppression of speech or association has to occur. Now, it occurred to me in thinking about this video that another helpful precedent, I suppose, that we could look at too is a case from during the Obama administration. That was the Humanitarian Law Project v. Holder. And in that case, Congress passed a law to ban nonprofits from providing material support to terrorist organizations. And nonprofits rightfully brought a lawsuit to say, we engage in all sorts of helpful sort of conduct with organizations, and maybe you've labeled some of them as terrorists, but we're not acting in any capacity that damages the United States or aids their terrorist function. We send doctors over, we provide education, we send medicine or food. And the reasoning of the Supreme Court was that there was at least a sufficient showing of a nexus to national security, because it viewed any of these things, sending doctors, food, medicine, as being sort of fungible. That is, if you're sending doctors and food to an organization that's purportedly terrorist, it can spend now more additional money, that's the money it would have spent on that, for its terrorist operation. So the Supreme Court saw a direct connection there. That it did assure the nation that there had to be that sort of tight fit between real actions that would harm America and in direct ties that would benefit these organizations. The opinion there is written by Chief Justice Roberts, and I think it tracks to a bit more of the deferential opinions that we see in the Schism Pentagon Papers cases. It's unclear. It's been some time since Holder, so it's unclear exactly how tough the Supreme Court is going to be on the executive branch, or if it's going to be a bit more like Holder or some of the more relaxed justices in Pentagon Papers. I suppose my hopes in the case are, as I already mentioned, one, that there's a bit more transparency that comes out of this. Just having a heavily redacted documents or completely unavailable documents supporting the claims puts democracy in a chokehold. It puts it in darkness, and that does real damage to governmental accountability. I think demanding some measure of this being made available to the public only helps the case of the United States and only helps the legitimacy of the Supreme Court. Doing anything in the darkness destroys that. Two, I'm not about deference in any sort of a case. I think that government, when it wants to act in some exceptional way, even if we're really scared about the Chinese, just as we were about the French, that government has to go to that extra mile to be able to put on its case and to be able to bring the evidence and show why it would need to target and shut down what we would otherwise think of as a fully First Amendment protected platform. Those are our thoughts here winding up today. I hope I've done a decent enough job of winding through some pretty dated precedent as we were able to walk through New York and explore some of its beauty and its ties to modern media and protests in America. As we get an update from the Supreme Court and an opinion, we'll do a short update response on this video. Thanks for watching.